Okay, so we're live. And before I begin the main subject of this video, I just wanted to address the Supreme Court decision briefly because one of my recent videos was dealing with the transgender decision in terms of em- uh, employment discrimination and the fact that the Supreme Court essentially extended the protections of the 19th Civil Rights Act to people who weren't even considered at the time that it was drafted and enacted into law. And this is just more something of of a similar vein. The idea being that not even an executive order, because deferred action wasn't in an executive order, it was a memorandum of understanding, and it was basically this series of decisions implemented through John Morton, the director of ICE at the time, at the behest of Barack Obama, who was basically pressured into creating this policy by Latino activists and activists for illegal immigration. And for those of you who are familiar with this, you'll remember that infamous clip where Barack Obama says he can't just use a pen to create laws that weren't. Basically, he can't create laws on a whim. And of course, he reversed that decision heading into his 2012 re-election campaign. So he issued this executive order that essentially granted immunity to 800,000 to 1.2 million, covered in both this and DACA, essentially created an amnesty for them, this group, and then the broader group, which, if you combine the two, is basically somewhere between 1.5 and 3 million people who are eligible for this, including people who had come to the United States as young adults, anyone over the age of 16. So this wasn't just people brought here as children who had lived in the United States their entire lives, but that's a side issue. The point is, these were basically edicts issued by Barack Obama that didn't really have the force of the force of law, in the sense of they weren't enacted by the legislature, they weren't an executive order, and he didn't really have the prerogative to enact these things. He essentially just granted himself the the power to do it. And it's ironic that this administration is accused of usurping powers and being dictatorial, and all sorts of epithets are used against it, used to describe it. And there are many substantive critiques that could be made of the current administration, but one of the things is that they haven't really done anything on that scale of simply enacting laws that were rejected by the U.S. Congress, which is what Obama did, since these amnesties were repeatedly rejected by Congress. But that's that's basically the backstory to what happened. And of course, the U.S. Supreme Court affirmed this based on their reading of the Administrative Procedures Act, which is a very obscure law that it's essentially a process issue. The fact that what Donald Trump did as president was not kosher, according to a majority in the Supreme Court, which is really bizarre when you put into the context of him suspending something that the prior administration did in defiance of Congress and in defiance of constitutional law. So you have the Supreme Court essentially saying that he didn't do this correctly, in spite of the fact that he could have reversed DACA from day one. It really didn't have any legally binding authority. It was essentially something Obama did in order to placate illegal immigration advocates and radical Latino activists in order to satisfy his base going into what was thought to be a very competitive presidential reelection campaign. But I wanted to bring this up because it goes to the issue I was talking about in my earlier video, namely the fact that the Supreme Court is interpreting or misinterpreting, misapplying laws, either administrative procedures or congressional laws that are bad on its face. And one of the interesting things about this is that the Supreme Court, outside of one or two justices, primarily Clarence Thomas, but also Justice Alito to a lesser degree, although they have different, they have a different sort of they have a different textual reading of the Constitution, but I think they both have a firm grasp of this document, the Constitution, even though they come at it from slightly different angles. And this is one of the reasons you see Clarence Thomas, even in concurring opinions, he'll write a separate opinion, or in dissents, or in dissenting opinions, he'll concur with a separate dissent. And he doesn't get enough credit for his really original thinking when it comes to constitutional issues. Hi, Alice. But these are the only two justices, really, that people who respect the Constitution can count on to come to somewhat rational opinions. And Jeffrey Epstein, Richard, there's a blooper. Richard Epstein, Professor Richard Epstein at New York University, he's a really fascinating figure. I don't always agree with everything he says, and philosophically, he's somewhat different in the sense of coming at these issues from a utilitarian perspective. And I'm not a utilitarian, but he's one of the few legal scholars, public intellectuals, when it comes to the Supreme Court and these sorts of issues, that comes at it from a fresh perspective. He doesn't simply regurgitate the same ideas. He's one of the people that would admit that the Civil Rights Act contains all sorts of unconstitutional clauses, that it's accepted. It's simply accepted within almost the entire legal community that this is a constitutional law, and that the motivation was good. Therefore, this should be upheld and expanded upon. And he's one of the few legal scholars that would challenge that. And he does this in all sorts of issues. For example, the idea of expanding administrative law. And this is one of his specialties, that this concept that, hi, Alejandro. Hi, Air Church. Hi, Christine. He's one of the few people that challenges this idea that this ever-expanding administrative law in agencies like the EPA and OSHA, and all of these agencies to which rules like the APA would apply, and which have encroached more and more upon the constitutional parameters of things like the legislature and the executive. He's one of the few people that would challenge the idea that this is constitutional, that we should just accept rulemaking bodies passing down the equivalent of laws and creating laws on their own with no no legislative input. So even though I come at it philosophically, I have some differences with him. He's still one of the most brilliant legal scholars and um, one of the most independent minded in terms of looking at these issues and looking at the Constitution from a perspective that was a lot more common prior to the 20th century, particularly prior to the rise of progressivism, Wilsonianism, and later on FDR and the New Deal. They pretty much crushed this notion that the Constitution should be a vehicle for liberty and conserving liberty, and that anything that contradicts that should be challenged. So Richard Epstein. I don't. Uh, I haven't gotten enough sleep the past week. That this explains it. But Richard Epstein, um, he used to, and as far as I know, he still does. I don't listen to the show that often, but he used to give interviews to the John Batchelor program, which is the local talk radio show, a late night talk radio show on WABC 770 WABC here in New York. And yeah, these were fascinating interviews. And one of the great points he made, almost as an aside, when he was talking about the composition of the Supreme Court and the approaches of different justices, he made the point that, with the exception of Clarence Thomas, and even here he departed a little bit, he said, uh, because Clarence Thomas doesn't have a parallel view to Epstein, but he's the sole justice that kind of understands where Richard Epstein and libertarian constitutionalists, where they're coming from, and understands their concerns and expresses them on the court. Hi, John. And he said, with the exception of Thomas, there's no one else on the court. I believe this was before Samuel Alito was confirmed, but there's no one else on the court who even understands this. All of these people, Kagan and Sotomayor, and obviously Ruth Bader Ginsburg, Breyer, and John Roberts, who's sort of the current version of Anthony Kennedy, who simply decides things based on how well it will reflect upon him publicly, how well the Washington Post, or how vehemently the Washington Post will praise him, which is even more cynical, and in certain ways it's almost more offensive than the four quote-unquote the four leftist justices who have firm convictions, even though they're based on faulty premises and really muddled thinking. At least they have certain convictions. For example, the idea that the Constitution should just be molded in order to foster progressivism. At least they hold that sincerely, whereas Roberts has no core to his being. He's simply a weather vane who enjoys being the Chief Justice and enjoys the perquisites of that office. But they at least have firm convictions. But the only one out of all of these people, even on the quote unquote conservative side of the bench, who understands these issues and looks at them through the prism of the Constitution conserving liberty and individual rights, the only person who even glances in that direction is Clarence Thomas. And Richard Epstein's point was valid. He said he's the only one. You don't even have. So someone arguing from the perspective of Richard Epstein, or I'm trying to think of another libertarian or liberty-minded scholar who understands the limits of the Constitution and the danger of enunciating positive rights, that you have a right to health care, you have a right to a stable income, all of these things which which can be traced back to progressivism. The only person who understands these things uh, and who has the intellect to analyze them and put forward their uh, this originalist understanding of the Constitution is Clarence Thomas. So essentially, you have 8 other people who are just going along with consensus opinion and just doing what, like I said, you have 4 hardcore leftist progressives who want to use the Constitution as a vehicle to mold and shape society in their image, and you have Roberts, who's who's pretty much the definition uh, of a soulless social climber who do anything in order to get rewarded by the ruling elites and be seen as a member of that echelon of society. And there's really no one on the Supreme Court enunciating a contrary view, this like a traditional understanding of what the Constitution means. So I think that's the issue people have. So the conservatives and the right, who the member uh, conservatives, libertarians, right wingers who are upset over these Supreme Court decisions, they should go back and look at it from the perspective of what the Supreme Court is and what its role has been, particularly in the post New Deal era, and then in the post Warren Court era. And their goal has been to use the Constitution as a vehicle for socioeconomic change and transforming the country. That's basically what's happening. So they shouldn't express shock or the fact that some of Trump's Supreme Court nominees went bad or this or that. I think they have to understand this in the long. They have to take the long view of how the country has been evolving, and particularly legal institutions. And you have to understand this is what's taught in law schools, and it's not something that just magically appears in a decision written by the Supreme Court. These are ideas that have germinated in law schools for decades. Okay, I'm gonna have to change the title of this because I'm running really long, and I want to wrap this up. But I'm gonna do a video about woke sports media in the future, either that or an Instagram live about it for those of you who follow me on Instagram. But anyway, like as all the other YouTubers say, like, share, subscribe. I will see you all next time. Hi, Carm.